I've spoken a little bit about Indian Penal Code, the old Indian Penal Code, the new Bharatiya Nyaya Sanhita. I've spoken a little bit about Bharatiya Nagrik Suraksha Sanhita, and I would add some more to that. Now, some more would mean there are these provisions which were dealing with prohibition to carry arms. There was the section 144A of the CRPC, which conferred power on the district magistrate and the state government to prohibit carrying of arms in possession of mass drill or mass training. Those provisions have been deleted as such. And there are provisions regarding maintenance proceedings also. Some of you all might be aware of this section 145, of this new law, section 145 of this Bharatiya Nagrik Suraksha Sanhita. In that provisions for maintenance are made. And those can be initiated with this new law coming to being at the place where the dependent father and mother resides. Father or mother, where they reside, they can initiate those proceedings from there itself. So jurisdiction-wise, it has been made convenient. So looking at it from the citizen point of view, it is really, really helpful provision as such. Okay. Now, of course, some states are ahead in terms of this law as such. Some states are provided for maintenance to grandparents also. Have our legislature missed an opportunity? It may not have been brought to their notice. We were always free to suggest whatever changes we want or object to the changes that were being brought about. And if we have done a proper job, perhaps those changes also would have come about. But there is always scope for further improvement that can happen with the passage of time. But as of today, what has been done is really good, I would say. And only time will tell how far, some provision, if they get challenged, whether they stand the test of constitutional virus or not, that only time will tell. Then there are provisions regarding proclaimed offenders as such. Okay, under this new law, proclaimed offender, he can be declared in all offences which are punishable with imprisonment for 10 years or more, or with life imprisonment or death. This is, in short, something to do with your Criminal Procedure Code. Now, without wasting much time, because I'm conscious of the time that we have at hand. Now, I'm moving on to the third law, which is called, earlier it was called Indian Evidence Act 1872. Now it is called Bharatiya Sakshya Adhiniyam. Bharatiya Sakshya Adhiniyam. This Sakshya Adhiniyam, as my senior colleague has pointed out, it replaces that Indian Evidence Act 1872. Now, applicability of this new law has been extended to court-martial proceedings as well, which are not there earlier. Court-martial proceedings, which are convened under Army Act 1950, Naval Discipline Act, or the Indian Naval Discipline Act 1934, or the Air Force Act 1950. Then this new law, Bharatiya Sakshya Adhiniyam, it primarily broadens the scope of this Evidence Act as such, and it addresses admissibility of digital evidence to keep pace with the advancement of the contemporary world. The world is moving ahead at a very fast pace, and we were required to keep pace with it. This law has done that, which would enable us to keep pace with the advanced technology as such. Now, this very definition of evidence, that has also been expanded, and rightly so, to include statements made through electronic mediums, facilitating electronic deposition for witnesses, offenders, experts, and victims, and thereby it would reduce logistical challenges to a great extent. Then additionally, this electronic and digital records, they are now classified as primary evidence. Earlier there was secondary evidence, now it is primary evidence under this section 57 of Bharatiya Sakshya Adhiniyam as said. And thereby it is underscoring their importance in the legal proceeding. Primary, nothing more needs to be done. You don't have to give notice, you don't have to resort to those kind of procedural thing whereby you have to bring secondary evidence on record as such. Now this colonial era terminology, like vakil, pleader, then you had barrister, all those needed to be done away with, and that has been done with this new law. And it is replaced with simply a word called advocate. thereby modernizing the legal languages. That is also good incorporation. And you'll be surprised to know, if at all you're not familiar with the things which are already there in the old law, there were terms and phrases like Parliament of the United Kingdom, Provincial Act, notification by the Crown Representative, London Gazette, any dominion, colony of possession of His Majesty, jury, Lahore, United Kingdom of Great Britain and Ireland, Commonwealth, Her Majesty or by the Privy Council, Her Majesty's Government, copies or extracts contained in the London Gazette or purporting to be printed by the Queen's printer, possession by the British Crown, Court of Justice in England, Her Majesty's dominions. All these are now a thing of the past. This colonial terminology, archaic terminology, all this has been done away with, and it needed to be done away with. There would have been they were little an eyesore or an obstacle, as in when you read the old laws. Now, rightly, they are done away with. Okay. Also, this word coercion that has been added as one of the elements causing confession to become irrelevant under Section 22 of this new law as such. Okay. I'll carry on informing you all, or rather educating you all, or apprising you all of few more things here and there, so that it becomes easy for you to appreciate what it is. Okay, what this new law entails as such. Now, as I said, this act, these new laws, they are intended to overhaul this Indian legal system, and the whole intention, the whole purpose is to establish a justice system which is based on Indian thinking. Believe me, there's a difference between Indian thinking and non-Indian thinking, I would put it that way. So, as I have been pointing out all along, in whatever I've said so far, this criminal laws, old ones had their own problems. Now this new criminal law will set people free, looking at it from a citizen point of view, from their colonial mindset, or its symbols, and decolonize our minds as such. It is meant to do that, the whole purpose is that. And this new laws tend to focus on justice rather than punishment. See the shift, see the paradigm shift that is happening, focusing on justice rather than on punishment. I say this because one of the things I can point out at this juncture itself, the community service. It is not that we are trying to punish that person, we are trying to reform that person. So there's a shift from punishing a person to bringing about justice. Also, there is that, using Indian terminology, there is that sabke saath samman vyavhar. There is equal treatment of all the people across, all the stakeholders across, samman vyavhar. You're not treating somebody unequal, like we are bringing about gender neutrality and all those things. So, samman vyavhar. Whether we are falling short somewhere with regard to fulfilling this objective, maybe so, but as we go along, many more changes can be brought about as the need arises and whenever it can happen. Then there is this whole thing reveals the real spirit of the original Indian Code of Justice. It was also said by some colleagues of mine that earlier there was that colonial mindset of punishing people. Now the whole purpose is to bring about justice. It's not to punish people for the wrongs that they do, but to bring about justice. That is the whole endeavor. Also, these laws in a way guarantee freedom, personal freedom of expression. Also, the value of human rights is at the core of all these laws. And it ensures a victim-centric justice as such. Then the soul of this new laws is nyaya, justice should be done, samanta or nishpakshata, without taking any sides, without any prejudice, samanta, similar, equal treatment kind of, that is at the core of it. And there is the spirit of Indian ethos, which makes a paradigm shift towards more citizen-centric approach. The Indian ethos, the Indian taste has been brought into it. Not just the taste, it affects us one way or the other, depending on what ideology we are following, what is our mindset, whether it's an Indian mindset or some other mindset. So this, I've already mentioned this. This, let's say for example, this section 173I of this new law, new criminal law as such, criminal procedure code. That gives citizen to file an FIR, right to file an FIR through oral or by electronic communication. So you can initiate that FIR orally or by electronic communication, irrespective of the area where the offence is committed. Citizen can file a FIR. I will be elaborating more on this as I go along. If somebody needs to know right away, I may lodge an FIR by sending a communication electronically, and within 3 days I've got to go and sign that FIR. Now there could be question raised as to what the police officer does within those 3 days. Those questions I will address. Some questions I know there could be most frequently asked questions, therefore I will myself address them, so that somebody who rather doesn't want to ask such a question for the fear that it may be a too silly a question, I will be already addressing that question. Then if you see further, citizen is also entitled to get a free copy of FIR. Earlier it was the experience of some people, getting a copy of the FIR also was a much, not so easy, or it was they would have some problems to face, no? And that copy would come without any delay. Those provisions are there in 173(2) subsection 1. Now the police also are mandated to inform the victim on the progress of the investigation within 90 days under section 193(3) of this new law. No, so look at it, that was never there. No, victim was a victim and he remained a victim throughout. And all the time, the perception that he was getting, or the what he would always feel perhaps, is that look at the accused, he's getting away with everything, and here I am suffering all the more. Once I suffered because I was injustice was done to me by the accused, and by going to the court of law I'm suffering all the more because I don't even know what is really happening and where is the investigation heading to, when it will get over and all that. So he's got a right to be informed, no, about the progress of the investigation within 90 days.